thank you so much for considering the offer and taking the time to go over it, to go over the demand and a complaint letter that I attached, and especially thoroughly reading it. Because before moving forward, I believe it is important to clarify that our intention has never been to build up any tension, but rather to reach a fair and a reasonable agreement between both our clients. Because our focus remains on ensuring that the facts are correctly assessed and that an outcome is reached that reflects procedural fairness, legal standards, and proportionality, which we have to abide to because it's the law.
First and foremost, thank you so much for agreeing for this meeting. So I would like, I have gone through the details attached, the documents attached in your email, and I understand your client's dissatisfaction with our client's miscommunication and ineffective relay of information. We are aware that your client's discriminatory view in all of this event, but we can assure you that that was not our clients in any way, shape, or form discriminating against motherhood, and they were explicitly voicing their customers' concern. And although not directly affected your clients' hours, and our client was perspective was voicing not just the customer complaints, since it's a client-oriented business. They have to ensure their clients that their satisfaction, their needs, and their emotional anguish will be the first point they're tackling. And due to the numerous complaints that we've received about the lactating period, not just because they've seen it as unhygienic and unprofessional in the work environment, but it was because it would take time off her duty taking care of these individuals that raised the alarms. Because at the end of the day, the priority of our client's business is to maintain client satisfaction and, as I mentioned, client-oriented perspective.
Okay, I understand your point, Council, but I think it is important to clarify that this issue goes beyond client miscommunication. An employer cannot allow customers discomfort, like it was to some of your clients' to justify discrimination that is ongoing in the workplace, especially when it concerns a protected medical and maternal right. As you've read on the complaint, Mrs. Polanco expressed thoroughly the economic and medical need of pumping, which adds onto the maternal right to pump as the Human Rights Act provides. It's the New York law. And it was evident to plaintiff that the sole reasons her hours were drastically reduced was in retaliation to plaintiff's insistence to pump milk in the job. And although we understand what you're saying of protecting your customers, this cannot come in the way of harming and discriminating against my client because, or while she was doing it right, while she was acting correctly to the law, and while she was exercising this right to pump milk because she had an economic and medical need to do so.
We would like to address that it was not a punishment. Our client has effectively communicated with us, and unfortunately not with you, that the whole process was not a punishment based on her persistent perspective in breastfeeding, because we understand that it was a medical and economic factor that weighed into her need of lactating. But at the end of the day, as mentioned before, client satisfaction is core to our client's business. And they do expect their workers' finest and most devoted time to the work environment. The customers' complaints were just the tip of the iceberg that made us reduce their hours, because at the end of the day, it's the customers who request the hours and request the workers. So it was not in any way, shape, or form a punishment, but merely a lack of proper management on invoicing the situation to the client. So yeah, there's nothing that they could do now based on the poor management, but we can assure you that it was no punishment, and it was not in a discriminatory punishment just because she was persistent about lactating.
Okay, I understand where you're coming from in the sense of that you have to protect your customers' concerns, but protecting them doesn't mean that you're going to justify against my client, against your employer or your client's employer. That's the thing. We have to differentiate between your clients, like the customers of people care their needs, against the discrimination that my clients suffer because the defendants. So even so, I want to add that both defendants had a legal duty to engage in an interactive process to find a reasonable solution. So even though there must have been a misunderstanding and there must have been client concern about her pumping in the job, there should have been some kind of consensus and a aim to reach an agreement that they had to go on to, because there was no communication between them. Especially, like, there was one time where defendant Altamonte, she asked to meet with plaintiff and discuss her letter on the phone that she had sent. And Ms. Altamonte in that phone call stated that she would try to get her more hours, but that never happened. So that was actually a vague statement, vague communication. So it doesn't even, like, it proves her point even more that there was no communication. Thus, this is another action that, as you will see you have seen in count 1 of the complaint that I attached. This included that under New York law there has to be some consensus between them, and there wasn't. Additionally, plaintiff had to go, like my client had to go beyond her work. She still had to take care of her child. In New York, she also had to take care of her child in the Dominican Republic. She had to provide for herself, but she had to go the extra length, and she contacted a non-profit organization called The Better Balance that you have seen, whose mission is to protect and enforce women's rights with regard to pregnancy discrimination in the workplace. And attorneys there in A Better Balance left several voicemails, letters, emails to both of your defendants, and they never responded. They never took the time to even try to reach an agreement with my client. They just simply discriminated against her. And even though I understand your point of there was no retaliation against her, that same act of reducing her hours is retaliation itself, because you're discriminating against my client for reasons that are protected under law. And while I appreciate your issue, this wasn't a misunderstanding, as you pointed out. It was a breach of state and federal laws under New York and under the US law that protected my clients. And again, we're in all ways open to solve this in a pre-litigation manner, but this resolution shall reflect real impact that this discriminatory actions of your clients have had on my client's life and health.
We recognize the obligation under New York and federal law regarding lactating accommodations and the importance of engaging in a clear interactive process. In the interest of reaching, as mentioned before, a pre-litigation resolution, our client is prepared to offer the following: paid medical leave for the remainder of the lactation period, not as a discrimination view or perspective, but as a means of satisfying both your clients and our clients' clientele, since they have such opinionated and heavy burden, as stakeholders are the most important factor of people care in corporation, and a full reinstatement of her prior schedule upon return. And yeah, that's everything that our client is offered, available to offer. And we believe that this serves both parties' interest by restoring income stability in your client while avoiding a delay or cost or uncertainty in litigation.
Thank you. I do appreciate your willingness to discuss a possible counteroffer, but I firmly have to disagree with this proposal as presented. Because firstly, suggesting a paid medical leave until the lactation period is over is no reasonable solution. Rather, it is furtherly punishing my client for exercising a protected right. So again, as you can see in count 1 of the complaint letter, defendants are charged of more than 7 actions, including pregnancy discrimination and failure to accommodate lactation under New York law and New York City human rights law and the New York State human rights law, which protect and accommodate breastfeeding employees even more when there is an economic matter in the way. First of all, by proposing that she has to leave her work, even though she will be paid, that she has to leave her work because she is actually exercising her right, is nonsense. That goes against the law itself. again, offering to postpone her work until she stops lactating is in itself another act of discrimination. So in the common interest of resolving this matter, as we both have a common interest and not go over to the court, my client is open to consider a settlement that includes the following term: the monetary compensation of $110,000 as originally outdated in our demand letter, which was dated March 6th, because it reflects lost wages, emotional distress, and all the damages under the New York State and city law. This reflects not even, or it has to reflect what my client has had to go through both emotionally and economically. Second of all, we want to reinstate Ms. Polanco to her previous full-time position with 36 to 44 hours guaranteed. And thirdly, we want a written assurance of compliance with New York City lactation accommodation, because my client is really focused on this not happening to other women because they're exercising their right. And it has to include a designated private space and scheduled breaks to lactate. We believe that this proposal represents a good faith resolution, which will compensate Ms. Polanco for the harm caused, and also ensuring your party a less exposurable means and a less costly litigation.
So basically, understanding after this meeting, you've increased your petition not just from 110,000, not just 110,000 on compensation for damages, but a reinstation of her previous time position, a full-time position, and a written assurance of compliance with the NYC lactation accommodation requirements. Unfortunately, our client is not ready to increase the previous settlement. That's why we already established this meeting, is to recognize a negotiation process of whether it could be modified or changed to an extent. Instead, you've increased it. Our counter offer would be reducing it to $40,000 on damages and maintaining the other two clauses.
I have to disagree. I think it is very discriminatory proposing just $40,000, because you have to understand that this $40,000, it does not include the health that was caused, the mental health that was harmed, or how it affected her, the economic problems that she had to go through. She could not provide for neither of her daughters. She could not provide for herself. She had to make ends meet. She had to go through so much. She had to go to the extent to contact a nonprofit organization in order to protect her rights, which it shouldn't even be necessary, because it is a protected right, and your clients actually discriminated against her while exercising a protected right. So I cannot see how you would have to reduce more than, $7,000 damages, because I believe it is nonsense. And adding on to that, we added the third clause because in this meeting, I've actually acknowledged that your company, People Care, is not really conscious of the length that women's rights have to be protected, and it's not conscious of how maternal rights, as pumping milk, is necessary for some women, some families don't have economic or they lack economic needs, or they're struggling with that. So I think this 40,000 do not reflect the damages, and we both agree in the other two clauses. But my last offer is 90,000 in damages, and I will not go down to that, because you also have to consider that we have so much evidence. Our client has, or your client, has been accused of 7 actions under New York City law. So if you go into court in the litigation manner, in the normal way, you will have to pay for the damages that I originally proposed, so 110,000 plus the court expenses, which will be 100. That sums up to $210,000, which is way more than what I'm actually proposing. My client is proposing.
We see the 90,000 settlement, but if our client takes the 90,000, there's no reinsertion in the full working labor hours, and there's no written assurance of the compliance, because at the end of the day, she will pay her the 90,000, but she will not be reinstated into the working environment. We don't see it fit. We don't see it proportionate, since 110,000 was already excessively, and adding her to the payroll and assuring her job stability and financial stability through the next contractual relationship was already enough, and we already compromised enough with the 40,000 was already enough of compromising while maintaining the other two clauses. We believe 90,000, but she's not reinstated.
Then I'll have to see you in court. Thank you.
Thank you.